Dato DP Naban moderated this thought-provoking session entitled Annulled but Not Forgotten, Enforceability of Arbitral Awards. The speakers including Dato Sunil Abraham, Mr. Luen, Ms. Kim M. Rooney and Mr. Thayanathan Baskaran dwelt into the complex landscape of enforcing arbitration awards that have been annulled. The panel of speakers also explored the divergent approaches taken by different jurisdictions and analyzed case laws that have shaped the treatment of annulled awards.
Without further ado, let us proceed to the penultimate session of the day. This session is entitled Annulled but Not Forgotten, Enforceability of Arbitral Awards. For that, ladies and gentlemen, please put your hands together as we call our moderator for the session, Dato DP Naban, up on stage to kickstart the session. Thank you.
Good afternoon, ladies and gentlemen. The session this afternoon is essentially in the seat of arbitration, where the arbitration took place, set aside the award. Is that thereafter unenforceable, cannot be recognized? That's essentially the issue. To enlighten us on all of these issues, I have four of our colleagues, and I'll invite Kim. Could you come on stage? Quickly introduce Kim. She has practiced in Australia, UK, admitted as a barrister in Western Australia, solicitor of England and Wales, now practicing in Hong Kong. So she has a taste of a number of jurisdictions, and I'm sure she will enlighten us on a number of things. Next I call Lam Kolun. He, of course, most of you will know him. He's from Shuklin, and he does much of arbitration in this jurisdiction and other international jurisdictions. Then we have Tawa. Tawa practices in KL, and he focuses on construction arbitrations primarily, but he does other type of commercial arbitrations as well, and civil litigation. Then we have Dato Sunil Abraham. I'm sure most of you will know him. He's the partner of Cecil Abraham and Partners. He does both court, commercial litigation, and arbitration, and I'm sure he will also enlighten us on some issues. The controversy, if you all remember, we had an issue some years ago when the Zulu chaps wanted to initiate an arbitration first in France, then in Spain, got an award. We as our government took the position, really there is no arbitration clause in the agreement. A, B, there is no basis for you to initiate an arbitration, therefore we are not going to defend it. It's a complete nullity. But because of the New York Convention, the panelists will dwell in greater detail on that. But because of Article 5 and Article 7 of the New York Convention, you can't take such a simplistic position. Because whether it is enforceable or not, it depends on the jurisdiction and not merely at the seat of arbitration. And that you have to be very careful when advising clients. With that, I will give the floor to Kim, who will give us a full background of why we have all these controversies, and then we deal with the various articles, Article 5, Article 7, and Kolun will guide us there. We have got Sunil, who will deal with how does France deal with it, because ICC is seated in France. How do they deal with it? Then we have got Thayanathan, who will deal with how the English position. Then I go back to Kolun, who will also deal with how America deals with it, USA. And finally, we go back to Kim, who will talk to us about the Australian and Singapore position. Now, Kim.
Thank you very much, Datuk. And first of all, may I thank very much the organiser of this conference for the opportunity to be a member of this wonderful panel. So, as Datuk has said, I'm going to start with a few introductory remarks about the nature of an award, what recognition and enforcement is, and then mention the outline of Article 5.1e, which is the provision of the New York Convention we're focusing on. Luen is going to talk about some other provisions of the New York Convention before we proceed with the rest of the discussion. So, forgive me for going back to basics. So I'm going to try to cover what I'm talking about, which is why I'm looking at my watch, in 6 minutes. In terms of going back to real basics, what's arbitration? Well, for us in the context of international arbitration, we're talking about the process by which parties voluntarily agree by contract to submit a dispute or difference that they have or may have in the future as to their legal rights and liabilities arising from a legal relationship between them. So first of all, the dispute between parties, the contractual submission of it to a tribunal, which may consist of 1 or 3 or another number of private individuals who will issue a final and binding determination of the substantive disputes submitted to it. As we know, and this is subject to the law of and procedures of different jurisdictions, there's generally no right to appeal against the arbitrator's award, particularly in foreign or foreign-related arbitrations. And we before had a brief discussion. We're talking about how important Article 2 of the New York Convention is, which, as you know, is a provision in the Convention by which contracting states agree that their courts will recognise and enforce valid or arbitration agreements. But that's for another day to go into that further. So what is an award? As you know, there's no definition of award in the New York Convention. It is generally defined to include an element of finality. That is, that the arbitral tribunal makes, and I've already said this, a final and binding determination of the substantive issues referred to it for determination. However, the New York Convention, while not defining what an award is, does provide criteria for determining whether it applies in any given case. But for the definition of award, one really needs to go to the specific national court or jurisdiction's court, where one's seeking to recognise and enforce an award. It is clear from the title of the New York Convention that it deals with foreign awards. Of course, jurisdictions may for themselves decide what comes within that scope. And so you look at Article 1 of the New York Convention, it makes it clear that the arbitral awards are not considered as domestic awards from that point of view. Under Article 1, Sub-Article 2, arbitral awards includes both awards made by arbitrators appointed for the particular case and those made by permanent arbitral bodies. Article 5, as you know, and now we're coming to very familiar territory, sets out the grounds for objecting to recognition and enforcement of an award, and these grounds are used generally in set-aside applications where the award was made, that is the seat of the arbitration, or in the jurisdiction where recognition and enforcement is being sought. And as I've said, there are other provisions that Colin will outline. Now, as we also know, there is an expanding range of decisions by tribunals and by emergency arbitrators, for example, in various jurisdictions that are being called awards, but they usually will lack the element of finality, and so arguably, most people would say certainly, but arguably outside the scope of the New York Convention, and we're not talking about them today. We wanted to briefly mention the distinction between recognition and enforcement and execution. As you know, recognition is the procedure by which a party to an arbitration asks a national or jurisdiction's court to recognise an award as valid and binding upon the parties in respect of the issues of which it dealt, and to permit it to be enforced in that jurisdiction, generally as if it was a judgment. And execution of the award then proceeds generally under that national or nation or jurisdiction's regime for enforcement of judgments. Now, I hope I haven't, I've got 1 minute left, I think, so just going to Article 5.1e. What are we focusing on today? Well, Article 5.1e provides recognition and enforcement of the arbitral award may be refused at the request of the party against whom it's invoked only if the award has not yet become binding on the parties or has been set aside or suspended by a competent authority of the country in which or under the law of which that award was made. So what's clear from that text is that the courts to which an application for recognition and enforcement is made have a discretion, and the New York Convention provides no guidance as to the exercise of the discretion. And I think my time is up, so maybe I can move on to you, hand over to you, Colin.
Just before you start. You now realize that Article 5 of the New York Convention says it may be, uses the word may. There is no, it's not shall, and thus it gives the domestic jurisdiction a discretion. And Colin will give us the other articles in the convention which also deals with this issue. But that you see the fundamental difference between these arbitral convention, New York Convention of awards, and judgments of court where the reciprocal enforcement of judgments are used. Once the judgment is set aside in the home country, it cannot be recognized or enforced, cannot be registered. Whilst in arbitrations conducted under the New York Convention, very clearly the position is very different. Colin will guide us there.
Testing. Yeah. Right. Okay. Thank you, Dato Naban. As you have heard from Kim just now, she has actually quoted Article 5.1e of the New York Convention, and I think this has been also elaborated by Dato Naban when he says the word may is used in Article 5.1e, which essentially what we generally understand as it provides a discretion to the courts to decide whether or not to refuse the recognition and enforcement of such an award, which may have been set aside by the seat of the arbitration. Now, Article 5.1e, interestingly, does not prohibit the recognition and enforcement of an annulled award if it can be done pursuant to state's domestic law. So this, where we see this in Article 7.1 of the Convention, of the New York Convention, and if I may just quote this, it says that the provisions of the present convention shall not affect the validity of multilateral or bilateral agreements concerning the recognition and enforcement of arbitral awards entered into by the contracting states. The second part here is important. Nor deprive any interested party of any right he may have to avail himself of an arbitral award in a manner and to the extent allowed by the law or the treaties of the country where such award is sought to be relied upon. So these salient words in Article 7 seems to preserve the right party to enforcement of such an award. And the words used in Article 7(1) of the Convention is shall. Now, so as Article 7 essentially provides contracting states the freedom to apply more liberal rules for recognition and enforcement of awards. I mean, these two provisions will lay the foundation to what the subsequent speakers will be talking about when we venture into the different jurisdictions and how these provisions were treated when it comes to enforcement of an award that has been annulled at the seat of arbitration. By the side also, just like to highlight another provision, but this is not in the New York Convention, but this is in the European Convention on International Commercial Arbitration, and this is Article 9, and it essentially limits the applicability of Article 5(1)(e) of the New York Convention, and it reads as follows. It says, in relations between contracting states that are also, so contracting states means the contracting states of the European Convention. It says, in relation between contracting states that are also parties to the New York Convention on the recognition and enforcement of arbitral of basically New York Convention on the recognition and enforcement of foreign arbitral awards of 10 June 1958, paragraph 1 of this article limits the application of Article 5(1)(e) of the New York Convention solely to the cases of setting aside set out under paragraph 1 above. So Article 9 of the European Convention actually limits the applicability of the Article 5(1)(e). And there essentially broadly, there are 4 situations whereby such setting aside would be recognized when it comes to enforcement. Number 1 is generally the parties were under some incapacity or the arbitration agreement is invalid. Number 2, the party was not given proper notice of the appointment of the tribunal or the arbitral proceedings, or the party was unable to present its case. Number 3, the award deals with a difference not contemplated by or not falling within the terms of submission to arbitration or contents decision of matters beyond the scope of submission to arbitration. And number 4, the composition of the tribunal or the arbitral tribunal was not in accordance with the agreement of parties. So these are the 4 broad categories where if the award is set aside on this basis, then it will be recognized under the convention. Surprisingly, where the award is set aside on grounds such as the matter is incapable of settlement by arbitration under the law of the country, or that the recognition will be contrary to the public policy of the country, doesn't fall into any of these categories. So that is just along the side for you to take note of. More importantly, I think what the speakers will be covering later on will be how the courts have treated Article 5 and Article 7 of the New York Convention. Thank you.
Now we have Sunil, and he will be dealing with specific case, how the French court has dealt with this issue. Because it's a fairly controversial issue. One jurisdiction decides not to enforce it, not recognize it, despite it being, once it is set aside, the other jurisdiction says, no, does not matter. Let's examine it, and we will have the discretion. Sunil, please.
Thank you, Dato Naban. Thank you for the AIC for inviting us to speak today. So I think you must appreciate there are 2 schools of thought here. If you subscribe to the views of Albert Vandenberg, his position in his commentary is that once an award is set aside at the seat, that's it. There's no arbitration award left to enforce. However, if you subscribe to the views and commentary of the likes of Emmanuel Gaillard and Jan Paulsen, they take a slightly different approach in that there is a discretion vested in the enforcement court as to whether the award can be enforced, notwithstanding it has been set aside in the seat of origin. And in order to examine that, I think you have to look at the origins of where this has sort of come about. And really it has come about from 2 principal decisions from France. So the first case I will discuss is that of the Norselot case. And just to give you some background. So the dispute in the Norselot case arose from a termination of a commercial agency contract between a French company called Yugi Law, later to be known as Norse Law, and Pabalk, which was a Turkish company. The arbitral tribunal was established under the ICC rules with the seat in Vienna. The arbitral tribunal ordered Norse Law to pay various sums based on transnational rules rather than the law of the particular state. The award was initially recognized in Austria and France at the Court of First Instance. Thereafter, in Austria, the award was partially set aside by the Vienna Court of Appeal. In France, the decision of the Paris Court of First Instance was granted recognition of the award. That decision was then reversed by the Paris Court of Appeal, premised solely on a construction of Article 5.1e of the New York Convention. What then happened? The Paris Court of Cassation in Paris, which is the apex court, on 9th October 1984, overturned the judgment of the Paris Court of Appeal. In doing so, the Court of the Cassation relied on Article 7 of the New York Convention and Article 102 of the French New Code of Civil Procedure at the time. The Court of the Cassation held that Article 7 of the New York Convention vested power and jurisdiction in the French courts to recognize an arbitral award based on French law. As such, applying the Civil Procedure Code in France, it required a French court of its own volition to determine for itself what the extent of French law would be insofar as deciding whether to oppose the enforcement of the award. So in this regard, the Court de Cassation established a principle of law that Article 7 of the New York Convention takes precedent in situations that involve the application of Article 5.1e of the New York Convention. It should be noted that the Court of the Cassation did not, in the Norse Law case, set out any conditions under which an award might be recognized under French law, notwithstanding that the award had been set aside in the country of origin. So that's the first case that lays the initial background to the French approach. The second case is the Hill-Martin case. So this dispute concerned the payment of a commission by Omnium de Traitement et de Valorisation SPA, so also known by acronym OTV, which is a French company, to Hill-Martin Limited, an English company, for obtaining a contract in Algeria. So this was also an ICC arbitration. The curial law was that of the Canton of Geneva. The seat of the arbitration was Geneva, Switzerland, and the law of the contract was Swiss law. In the first arbitral award, dated 19th April 1988, the sole arbitrator held that the commission to be paid to Hill-Martin was not due on grounds because Algerian law, which was, although it was not the law of the contract, prohibited payment to intermediaries in such circumstances to procure a contract. OTV filed an application to recognize and enforce the first arbitral award in its favor before the Court of First Instance in Paris, and this was allowed on 27 February 1990. At the same time, Hill-Martin instituted proceedings in Switzerland to set aside the first arbitral award, and this was allowed by the Court of Justice of the Canton of Geneva on 17 November 1989. The Swiss Supreme Court affirmed the decision of the Court of First Instance in Geneva, right? And that occurred on the 17th of April 1990, which is 2 months after the Court of First Instance enforced the first arbitral award in France. When appeal was brought to the Paris Court of Appeal, the issue before the Paris Court of Appeal was whether to recognize the first arbitral award in France, which had already been set aside in Switzerland. On 19th December 1991, the Paris Court of Appeal, in applying Article 7 of the New York Convention, held that a judge may not refuse to enforce unless the national law so authorizes, and thereby muted the impact of Article 5(1)(e) of the New York Convention. The Paris Court of Appeal referred to Article 1502 of the new Civil Code, which is the French Civil Procedure Code, and observed that it does not include in its provisions as one of the grounds to refuse to enforce an award the fact that it has been set aside in the country of origin. The Paris Court of Appeal went on to state that the recognition of an award in France that has been set aside in the country of origin was not contrary to French understanding of international public policy. On 23rd of March 1994, the Cour de Cassation in Paris confirmed the decision of the Paris Court of Appeal by ruling that as the first arbitral award was an international award not integrated into the Swiss legal order, its existence continued in spite of it being set aside, and that recognition of the first arbitral award in France was not contrary to international public policy. Thereafter, arbitral proceedings were reinstituted by Hill Martin following the setting aside of the first arbitral award in Switzerland. The first arbitrator resigned. A second arbitrator was appointed. On 10th April 1992, a second arbitral award was handed down in favor of Hill Martin. Hill Martin then applied to register the second award in France before the Court of First Instance in Nanterre, not Paris, and this was granted on 25th February 1993. At the same time, Hill Martin applied to register the second award, arbitral award in Switzerland, and that was also granted on 17th April 1990. On 29th June 1995, the Court of Appeal in Versailles upheld the decision of the Court of First Instance in Nanterre on the basis that the first arbitral award did not crystallize the dispute insofar as the French legal order was concerned, and as such, the recognition of the first arbitral award did not bar recognition of a conflicting second arbitral award. The Court of Cassation in Paris on 10th June 1997 went on to reverse the decision of the Court of Appeal in Versailles on the basis that under Article 1351 of the French Civil Code, which codifies the doctrine of res judicata, as such, in France, only the first arbitral award is to be recognized as being enforceable, despite the first arbitral award having already been set aside in Switzerland. So by postscript, I just want to let you know that OTV did apply to set aside the second arbitral award in England on grounds of contravention of public policy. So Justice Timothy Walker, sitting in the Queen's Bench Division, on 24th of May 1991, dismissed the setting aside application and held that the second arbitral award was made under a foreign proper and curial law, which had specifically found that there were no corrupt practices, and as such should be enforced in England, even if English law would have arrived at a different result on the ground that the underlying contract breached public policy because its performance involved a breach of statutory regulations in the place of performance, which is Algeria in this instance. So you can see that there are different approaches here in different jurisdictions. The Swiss court took a particular approach. The French court took a very different approach and sought to exercise its own independence in deciding whether to enforce the award or not, and to justify the non-enforcement of the second arbitral award on grounds of res judicata. And then you have the English court's position in having to respect the position in Switzerland, albeit that a tribunal in the UK may have reached a different conclusion on grounds of public policy. So what are the takeaway points? I'll leave you with two for now. The first is that the French courts take the position that if a second arbitration is instituted and that second award conflicts with the first award, which has to be recognized in France, then the second award cannot be registered and enforced so as to bring finality to the process. And more importantly, the French courts and law makes it clear that reasons for setting aside an award in the seat is not a relevant consideration to any application to register or enforce an award in France. So in the context of Malaysia, if I can just bring it home for you all, if you look at the Hill Martin case, it really is a contract about influence peddling, procuring a contract. So how would the Malaysian courts have dealt with such a matter when it came to enforcement? Would the Malaysian courts adopt the French approach? Would they adopt the English approach? You know, it is a question that we have no authority on. But I think it'll be very interesting to see how our Malaysian courts deal with that, because they have ruled that, you know, influence peddling is perhaps contrary to public policy in two decisions, Marong Mahawangsa, which is a decision of the federal court, and Wong Yi Bun, which is a related decision also on a similar issue. So, you know, it remains to be seen in the context of Malaysia whether we will be as liberal as the French or perhaps more restrictive as the English court was in this instance, although there are subsequent decisions in England where a slightly different approach has been taken, perhaps on more fact-specific grounds. So I'll leave it at that for now.
Thaya will take us through the English position in greater detail. Thanks.
Hi, good afternoon, everyone. First of all, I'd like to thank the AIAC for inviting us to speak at the ADR week. I will be dealing with the English position this afternoon. We already heard a general commentary from Luen and Kim, and Dato Sunil has given us the position in France. So I will be looking at the position taken in England in relation to the enforcement of awards that have already been set aside in the seat. So there appear to be three main English decisions on this: UCOS Capital, Malikop, and Maximov. So what I'll be doing this afternoon is really going through the judgment in Malikop, which to a large extent adopts the general principles taken from UCOS Capital. So before I go into the theoretical side of Malikop, perhaps just very briefly on the facts. What happened in the case of Malikop and Egypt is this. There was a concession agreement where Malikop, a company registered in England, agreed to design, construct, and operate a new airport in Egypt. Disputes and differences, as usual, arose between the parties. And then Malikop proceeded to commence arbitration proceedings at the Cairo Regional Center for International Commercial Arbitration, which is one of the sister ALCO bodies. We heard from the director earlier this morning. What happened then was that the Arbitral Tribunal in Egypt gave an award in favor of Malikop. The award was signed by two of the tribunal members and was not signed by the third member. That award that was rendered was then set aside by the Court of Appeal of Egypt. At the time of the judgment of the High Court of England in Malikop, there was a pending appeal from the Court of Appeal of Egypt to the Court of Cassation in Egypt. And that is an issue also dealt with in the judgment of the High Court of England. So what then happened in the High Court of England was this. Malikop applied to enforce the award that had already been set aside by the Court of Appeal of Egypt. So Malikop applied to enforce that award in England. The High Court gave a preliminary order allowing that enforcement subject to Egypt's right to set it aside. Egypt, of course, then applied to set aside that enforcement order on two grounds. Firstly, that the award had already been set aside in Egypt. And secondly, during the arbitral proceedings, Egypt had not had an opportunity to present its case. The High Court of England allowed that application to set aside the enforcement order and refused to enforce the award that had already been set aside in Egypt in England. The High Court of England decided various issues of general interest. Firstly, the High Court of England held that the fact that there was a pending appeal from the Court of Appeal of Egypt to the Court of Cassation of Egypt was irrelevant, and as a matter of private international law, they would treat the decision of the Court of Appeal of Egypt as being final. Second, they went on to hold that the fact that it had been set aside in Egypt, that alone without more does not mean that there is no award to be enforced in England. They would still need to look at it and exercise their discretion. In this regard, they set out the general approach, or what they term the preferred approach, that will be adopted by the English courts. That preferred approach is actually based on an earlier English judgment in Eucos Capital. The preferred approach is this, that because of the use of the word may in section 103 of the English Arbitration Act, the English courts retain a discretion whether or not to enforce an award, even if it has been set aside in the seat. So you can have a situation where an award has been set aside in the seat of arbitration, but it may still be enforced in England, or it may not. Courts have a discretion. So that of course then begs the question, what is the basis for the exercise of that discretion? In that regard, the court held that that would be decided based on general principles with regards to the recognition of foreign judgments, based on which a foreign judgment will be recognized and enforced in England so long as it doesn't offend three basic principles in relation to honesty, natural justice, and public policy. So after setting out these general principles, what the High Court of England went on to do was to deal with the arguments that had been raised by Malikop for the purposes of challenging the setting aside decision in the Court of Appeal of Egypt. So firstly, Malikop had said that the decision to set aside in Egypt was simply wrong as a matter of law. The High Court in England said that was unacceptable, an unacceptable basis for not recognizing the judgment to set aside the decision, because as a matter of general principle, the courts in England would treat foreign law as something to be decided by the relevant foreign court. Secondly, Malikop contended that the judgment to set aside the decision in Egypt was tainted by pro-Egypt bias. In this regard, there was simply, the High Court simply held that there was no cogent or positive evidence to that effect. The second ground that was raised by Egypt in resisting enforcement was that they did not have an opportunity to present their case during the arbitration proceedings. With regards to the issue of a party's ability to present its case, the English court took the position that that would be a matter to be decided based on English principles and not based on principles applicable in Egypt. Based on English principles, a party's inability to present its case would no doubt occur where an arbitration award has been given for remedies that were neither pleaded nor argued by either party. In this case, the award given by the arbitral tribunal was for damages for a mistake in the contract. However, that mistake was not pleaded nor argued by either Egypt or Malikop. Malikop had argued that the concession agreement had been breached but had not alleged any mistake, and Egypt had argued that they could avoid the concession agreement because of fraud. So the court held that because no notice had been given of this issue of mistake by the tribunal to either Egypt or Malikop, that indeed gave rise to a breach of natural justice, and because this breach was so serious and grave, the courts would not enforce such an award. So that briefly is the judgment that was given in Malikop. I think the key issue really here is the preferred approach that was outlined in Malikop. Malikop is based on Section 103 of the English Arbitration Act 1996. Section 103 of the English Arbitration Act 1996 reflects Articles 5 and 6 of the 1958 New York Convention. And those articles are then reflected in Article 36 of the 1985 Model Law, which then in turn reflected in Section 39 of our Arbitration Act. If we look at the New York Convention, the Model Law, and the statute both in England as well as in Malaysia, all of them use the words may, which was mentioned by Kim earlier and emphasized by Dato Naban. So the word may there basically means that even if the award has been set aside in the seat of arbitration, the enforcing court retains a discretion whether to enforce the award or whether not to do so. That in itself, the fact that the courts have a discretion because of the use of the word may, that in itself is clear. The courts certainly have a discretion whether or not to enforce or not to enforce. What is I think different in various jurisdictions is the test that is applied for the exercise of that discretion. So in England, what was referred to as the preferred approach that was adopted was basically based on general principles on the recognition of foreign judgments. That those foreign judgments in general will be recognized so long as they do not offend natural justice, honesty, or public policy. So as you would appreciate, the preferred approach in England is to focus on the judgment setting aside the adjudication decision. They are not really looking at the award per se, but the judgment in the seat country that sets aside the adjudication decision. And so long as that judgment doesn't offend principles of public policy, natural justice, or honesty, it will be recognized and the award will not be enforced in England. This approach of focusing on the judgment setting aside the adjudication decision as opposed to the award itself does appear consistent with Article 5(1)(e) of the New York Convention, which refers to an award having been set aside by a competent authority of the country in which that award was made. So Article 5(1)(e) is effectively referring to the judgment in the seat setting aside the award. It's not referring to the award per se. So it's a fine distinction, but one that should perhaps be made. This is quite different from the position taken in France, where the focus is in fact on the award and not on the judgment setting aside the decision. The approach taken in France is based on the theory that an award, that an international arbitration award is not integrated in any national legal order. As the International Arbitration Award is not anchored in any national legal order and is instead a decision of international justice, such an award may be reviewed and enforced in accordance with the rules applicable in France, regardless of whether it has been set aside in the seat. So as you would have appreciated from what Dato Sunil mentioned earlier, the court's focus in France is really on whether the award satisfies the requirements of the Code of Civil Procedure of France. So long as the award satisfies those requirements, regardless of whether it has been set aside in the seat, it will be enforced in France. So the focus is on the award, not on the judgment setting aside the award in the seat. The courts in France do this on the basis of their code of civil procedure, on the laws of France. They don't do this on the basis of Article 5 of the 1958 New York Convention. In this regard, as mentioned earlier, they are in fact entitled to do so because Article 7.1 of the New York Convention allows for any jurisdiction to have a more favorable system for enforcement than what is provided for in the New York Convention itself. So it appears that France does have a more favorable system for enforcement that allows for an award to be enforced in France even where it has been set aside in its home jurisdiction. Yes, thank you.
Now we go back to Luen to tell us about what the position in the US is. Thanks, Luen.
Thank you, Dato Naban. Now, before we all fly to US, okay, I mean, you've heard of the experience in France, experience in London and all that. I think just to put things in context, why is it so significant how the other jurisdiction treats an award that has already been announced? It is a real problem because for those, say, assuming a parties to an award who has assets outside in various jurisdictions, it is a real possibility. For instance, if we take our Malaysian approach, assuming you have an award seated in Malaysia, you apply to set it aside, the other side applies to enforce it, to apply for they'll have to obtain leave to enforce it. You apply to set aside that leave. So under our Arbitration Act, the moment they apply to set aside that leave to enforce, the matter gets stayed. The enforcement in Malaysia gets stayed. But it doesn't mean that the winning party cannot go elsewhere around the world and try to enforce it. Okay? And this is a real possibility. For those who's in arbitration, practice arbitration, you would have heard of the case of Government of Laos and Thai Lignite. It is a real case whereby an award was obtained by Thai Lignite and another against Government of Laos in a tune of about 57 million USD against the Government of Laos. The arbitration was seated in Malaysia, in Kuala Lumpur. So the Government of Laos were not happy with it, obviously, sought to challenge that award in Malaysia, applied to set it aside in Malaysia. There were enforcement proceedings. So the proceedings were ongoing in Malaysia. But that doesn't stop Thai Lignite to actually pursue enforcement elsewhere. So what they actually did is that they went around the world. They went to London, they went to France, they went to New York, and they went to Singapore. In all these jurisdictions to actually seek enforcement of the award whilst the setting aside proceedings were ongoing in Malaysia. Now, in the States, in New York in particular, what actually happened was that they went before the district court, and the district court judge, Judge Kimba, actually granted, allowed the enforcement of the award whilst all these things were going on. So there was an enforcement order in New York. Does that mean the end of it? Eventually, the arbitration award was set aside by the Malaysian courts. From the High Court, by the Court of Appeal, all the way up to Federal Court, it was set aside. But does it mean that's the end for Government of Laos when there was already an enforcement order in New York? I'll come back to that later. So then I'll bring us all to US, to New York. Now, in the US, I think back in the 1996 or 1997, the US approach seems to be similar to what the French courts have adopted. In other words, the US courts were quite prepared to enforce an award even though the award may have been annulled by the seat of arbitration. And that was the case of Cromoloi. The Cromoloi case, what happens is that the US District Court allowed an application to enforce an award that was rendered in Egypt and which was subsequently annulled by a court of appeal in Egypt. The case concerned the enforcement of an award rendered in Cairo in an arbitration that involved US company Cromoloi against Republic of Egypt. Tribunal awarded Cromoloi over 18 million and applying Egyptian law as stipulated in the contract. Now, Cromoloi sought enforcement of the award in the States. The Republic of Egypt appealed the award before the Cairo Court of Appeal, the Court of Appeal in Cairo annulled the award. Then later, the Columbia District Court granted Tremolai's petition to enforce the award, notwithstanding the annulment of the award in Gilt. So that was in 1996. The court considered that in contrast to Article 5 of the New York Convention, which sets up a permissive standard under which a court may refuse to enforce the award, Article 7.1, which mandates that this court must consider the interested parties' claims under the applicable law, and then concluded that whilst Article 5 created a permissive standard, leaving non-enforcement of an annulled award within the discretion of the judge, Article 7 was a mandatory provision, enshrining the parties' right to invoke more favorable enforcement provisions of national law when enforcement was sought. So, in 1996, it appears as if the US was actually following what the French was doing. Now, so the Tremolai decision is built on the following assumptions. One, Article 7 of the Convention gives a party the right to obtain enforcement of a foreign award under the more favorable rule of domestic arbitration law. Two, the enforcement of the foreign award must therefore be examined under the local laws, which is the FAA, rather than Article 5.1e of the Convention. And only if the foreign award is so defective that it can be vacated under Section 10 of the FAA will the foreign court's annulment decision be recognized in the United States. So since the validity of the foreign award was to be examined under Section 10, the local laws, and there is no preponderant role of the jurisdictional seat in determining the validity of the award. Now, and they went on to deal with the public policy in favor of arbitration and says that that was sufficiently strong to override the considerations of committee when deciding not to grant res judicata effect to the foreign annulment decision. Now, so in 1996, we thought US was going to follow French and all that. But surprisingly, over the years, the position seems to have changed. And in the more recent years, I think a couple of years after the Tremolai's decision, there was this case of Becker Marine against Chevron. And again, it was actually decided by the US Court of Appeals in 1999. In that case, Becker Marine contracted with Danos and to supply certain barge services for those companies. An award was given, made against Danos and against Chevron. The arbitral proceedings took place in Nigeria, and it was there that Baker initially sought enforcement. However, the Nigerian court set aside both awards, determining that the tribunal findings were not supported by evidence and that the tribunal had improperly awarded punitive damages beyond the scope of party submissions. Now, Becker then sought enforcement of both the awards in the United States under the New York Convention. The district court denied Becker's petition and says that the principles of committee, and based on the principles of committee and also under the New York Convention, and says that it would not be proper to enforce a foreign arbitral award under the convention when such an award has been set aside by Nigerian courts. So the tide seems to have changed, where the US courts now seems to give committee to the courts of the seat. Now, in the appeal, Becker Marine argued that the district court had failed to give effect to Article 7 of the convention, the Article 7 that we have mentioned, the shall, and that Becker had the right to have the awards recognized under the more favorable provisions of the FAA, essentially relying on the decision of Tremolai to put forth the argument to the appeal courts when appeal against the decision of the district court. The Court of Appeal did not agree with Becker, and this is what they said. We reject Becker Marine's argument. It is sufficient answer that the parties contracted in Nigeria, that their disputes would be arbitrated under the laws of Nigeria. The governing agreements make no reference whatever to United States law. Nothing suggests that the parties intended United States domestic arbitral law to govern their disputes. The primary purpose of the FAA is ensuring that the private agreements to arbitrate are enforced according to their terms. Furthermore, Bakers have made no contention that Nigerian courts acted contrary to Nigerian law. So that seems to be the position after a few years after the Tremolai. And we then look at whether subsequent to that were there new developments. I think the position has remained the same after Baker, and there was a subsequent case called the case of Temorio versus Electranta. And similarly, in that case, the award was also annulled in the seat of jurisdiction, The parties tried to seek enforcement, and it was also refused. Such enforcement was refused. And in that particular case, the Court of Appeal went further to say that the United States' emphatic policy in favor of arbitration is not in itself a public policy objective enough to justify ignoring a foreign judgment, essentially rejecting from a lawyer. Now, moving on from there, we have a more recent case, and this case then again tilt the balance to the other side. This is the case of Pemex Exploration. Pemex Exploration was decided in 2016. The Court of Appeal decision was in 2016. Now, in that case, what happened is that Corporation, which is the party who actually obtained the award, obtained an award against Pemex. Okay? The award was annulled in Mexico on the basis that Pemex, as an entity deemed part of the Mexican government, could not be forced to arbitrate. Okay? So it was actually annulled in Mexico on that basis. The Court of Appeal affirmed the District Court's decision to allow the enforcement of the annulled awards. So they went to, after the award was annulled in the Mexican courts, they went to Corporation, actually went to US and tried to seek enforcement. District Courts actually allow it. Okay? So that seems to, again, swing the pendulum to the other side. Now, and the Court of Appeal even affirmed the District Court's decision to allow the enforcement of the annulled award, because it says, because giving effect to the subsequent nullification of the award in Mexico would run counter to United States public policy and would, in the operative phrasing, be repugnant to fundamental notions of what is decent and just in this country. So that's what the Court of Appeal actually said. So in that particular case, whilst the court actually confirmed the standard set in Becker Marine and Termiorio, recognizing that any court should act with trepidation and reluctance in enforcing an arbitral award that has been declared a nullity by the courts having jurisdiction over the forum in which the award was rendered, it nonetheless became one of the recent cases in US that enforced an award that's annulled in its primary jurisdiction. Now, this was quite a controversial decision, and all these cases were there. And what happens to government of Laos? You have got an award which has been recognized, but subsequently it was annulled in the seat of jurisdiction. Can we go back to US and say, okay, look, it's been set aside now, it's been annulled, can we remove that particular enforcement order? Now, that's where the government of Laos went back to US, went back to US, and sought to vacate that particular order that is enforced the award after it was set aside by the Malaysian courts. It went before the same district court judge, and surprisingly, the district court judge actually set aside or vacated that particular enforcement order. Now, what the government of Laos did was that they moved under the Federal Rule of Civil Procedure 60B5 to vacate the district court's judgment enforcing the award. The judge would granted the motion, finding that the Malaysian High Court's decision to set aside the award on a universally recognized ground did not meet the extraordinary circumstances envisioned by Temio and vacating her prior enforcement order. So just recollect, the award was set aside in Malaysia on the basis that the tribunal had exceeded its jurisdiction, has gone beyond its scope of power. So it went before the Judge Kimber, and she took that as into account and decided to vacate the award. Thai Lao Lignite was not happy with that decision, obviously, appealed to the Court of Appeal, or rather the Second Circuit. The Second Circuit panel concluded that Judge Wood did not abuse her discretion in vacating her earlier judgment in enforcing the arbitral award in light of the annulment by the Malaysian High Court. Then it once again, the Second Circuit actually once again reiterated the high standard for enforcing a nullified award set out in Becker Marine and Termio, and cited Pemex Primary to note that it too recognized a strong presumption in favor of following the primary jurisdiction's ruling. Now, although the Thai Lao Lignite panel or the Second Circuit recognized the need to determine how this presumption applied in the unique procedural posture of the case before it, the panel did not hesitate to find that Rule 60b-5 applies to district court orders enforcing foreign arbitral awards under the New York Convention. And then the panel further held that annulment of an arbitral award in the primary jurisdiction should there be given significant weight in the Rule 60b-5 analysis, especially in the circumstances of the case at hand, where although we might not necessarily agree with the merits of the Malaysian court's judgments, we see no grounds for public policy concerns. So in that case, it seems that now the US courts have turned back to recognize committee. Now, although we see that there seems to, okay, so what does it mean? On the one hand, Permex has said they're going to enforce and annul awards. Government Laos, on the other hand, they have actually decided not to actually enforce it. In fact, vacated an enforcement order that was given earlier, and on the grounds that the award was subsequently set aside by the seat of jurisdiction. I think you can actually draw a comparison between these cases, and they can actually, there's a reason why perhaps a decision in the government of Laos was decided as such, and there's also probably a reason why Permex was decided as such. Now, a comparison can be drawn between Permex and government of Laos. Now, in Permex, the foreign award annulled was confirmed by the district court. Okay, Thai Lat Lignite, the same court deferred to the foreign annulment. Now, Thai Lat Lignite does not indicate a backtracking by the district court for the Southern District, proposition that in some circumstances annulled awards can be enforced in the United States that it adopted in Permex. Now, the difference here is that in Permex, the Mexican court's judgment were unquestionably tainted by a serious flaw. Okay, so the reasons why it was annulled was actually different in Permex as compared with the government Laos. Government Laos, it was actually annulled or set aside purely on those jurisdictional grounds. So I suppose maybe the courts, the US courts, have considered these differences in deciding differently earlier in Permex and subsequently in the government of Laos case. So that seems to be the position in US. If I may do so, I'll probably sum up. Generally, the US courts in the recent judgments seems to recognize that if an award is annulled at the seat of the arbitration, then they will not enforce it. But they may go and they may decide to enforce it in circumstances like what's happened in Permex. So I mean, it's important to understand how these different jurisdictions deals with awards that's been set aside, because for those who have actually assets in various jurisdictions, these are real possibilities. That's all I have. Thank you.
We now hear Kim again in regard to how the Hong Kong and Singapore courts deal with the issues. Thanks.
Thank you very much, Datuk, and thank you to my colleagues who've gone before me, who've canvassed enormous amounts of geographical territory, very complex legal concepts, very succinctly. And I know we still have a final part subject to the Datuk's determination, so I'm just going to speak very quickly about Hong Kong, where I'm admitted, and touch on Singapore, where I'm not, but referring to publicly available sources. And as to Hong Kong, I guess my headline point is that Hong Kong courts consider they have a discretion whether to recognise and enforce an award, even if it's been annulled in the seat of the arbitration. But that being said, it would be slow to exercise such a discretion. That different courts in one jurisdiction can take different approaches has been illustrated by my colleagues' masterful presentations. But let me give you an example in Hong Kong. Now, this is a case which many of you would be familiar with, Astro Nusantara and PT Ayunda. And that was a case, and I'm going to say this, I've been asked to go to the facts, so I'll briefly mention the facts. Astro and other companies headquartered in Malaysia entered into a shareholders agreement and subscription agreement with Indonesian parties. Disputes arose. There was an arbitration in Singapore under SIAC rules. It was an international arbitration. And these proceedings were commenced by 8 parties, but only 6 were parties to the arbitration agreement. So remember, right at the beginning, we were talking about how an arbitration agreement is fundamental to the scope of jurisdiction of the tribunal. So in these proceedings commenced, only 6 of the 8 claimants were actually parties to the arbitration agreement. And there was an award in favour of the applicant, and applicants and enforcement applications were made in Hong Kong and Singapore. But then the unsuccessful parties sought to set aside the award in Singapore, complaining that 2 of the parties, the applicants, had not been parties to the arbitration agreement, and hence the tribunal had exceeded its authority and didn't have jurisdiction to make the award it did. Now, there's one school of thought, as we've heard, in this area, which is along the lines that once an award has been set aside, there will be nothing left to enforce for a court, let alone any residual discretion to enforce. And that's because the legal basis has fallen away on that theory. Now, at Hong Kong, we're talking about 3 levels of court in the superior courts: first instance, single judge, then Court of Appeal, then our apex court, Court of Final Appeal. Now, the Court of Appeal, that's the second one in that tier, remarked in this case that it will indeed be remarkable if, despite the Singapore Court of Appeal judgment being the court at the arbitral seat on the invalidity of the arbitration awards, the award creditor will still be able to enforce a judgment here based on the same arbitration awards that were made without jurisdiction. But despite it being said that that would be remarkable, both that Court of First Instance, the first court, and that intermediate court, the Court of Appeal, would have denied an extension of time to challenge the enforcement of the award, which had been determined by the Singapore Court of Appeal to be made without jurisdiction, on the basis that the award debtors were not parties to the arbitration agreement. Now, why? Why would they have done that? And indeed, those decisions were ultimately reversed by that highest court, the Court of Final Appeal in Hong Kong, which granted the award debtors an extension of time. Well, when at the first and second levels, such matters were considered as whether or not the respondents had raised this jurisdictional issue during the proceedings, and also how long they'd taken to seek to set aside and or seek to object to recognition and enforcement. But the Hong Kong Court of Appeal considered that the lack of these 2 parties, that the 2 of these parties were not parties to the arbitration agreement, 2 of the claimants, were so fundamental, such a fundamental breach, that time should be extended. And there have been subsequent decisions in Hong Kong talking about the criteria courts should apply in these situations. Now, moving on very quick, I know it's a complex topic, but I know we've running out of time. Moving on very quickly to Singapore, may I refer to a decision in PT First Media, TPK, and Astro Nusantara International and others on appeal in 2014, where in obiter comments the court expressed serious doubt as to whether it would retain a discretion to enforce an award that has been set aside at the seat of the arbitration. But there's various cases in Singapore that have canvassed the issues, and my understanding is, though I must emphasise, I'm not admitted in Singapore, this case is not, this situation is not the subject of a final decision. So thank you, sir. That's all I wish to say about Hong Kong.
You know, you realize that an arbitration award is really a danger if it's made in international arbitration, because it can be enforced in 170 over countries, and each country decides the standards, the basis, the jurisprudence on whether it should be set aside or not. They give some priority, as you have noted, as when the arbitration award is set aside in the seat of arbitration, that jurisdiction. But it is not the complete answer position. They still examine it and then decide for themselves. So it is that, thus there is this confusion. You know, you have the Zulu case, you have got the Laos case, where arbitration award has been set aside, yet it is being enforced in various jurisdictions. So consequently, is there a way forward, both from jurisdictional position and from commercial position, to have an international standard? I ask each of my panelists their views. Kim, would you?
Thank you very much, sir. May I briefly refer to an analysis that Professor Gaillard has applied, which has been referred to by one of my colleagues, as to when the enforcing court will follow the court at the seat and when it will not. And he's analysed it as there being three different approaches, and I'm indebted to Justice Stewart in his paper, Navigating the Rough Seas of Enforcement, who goes through this. And I think we've heard all three approaches discussed today. The first is, which may be termed, he uses the mono-local view, that arbitration is anchored to a single national legal order, the seat of arbitration, such that the award's validity stems exclusively from the law of the arbitrator seat. The second view, which Professor Gaillard calls the multi-local or Westphalian theory, is that an award's validity is grounded in a number of different legal systems, and so each state has exclusive sovereignty, is protected from interference by others, and it's the systems of law that are willing and under certain conditions will recognise the effectiveness of the award, or the systems of law where enforcement is sought that are implicated. And it's suggested, now I know we're getting into very jurisprudential areas, but it's suggested that in this area, in this approach, the law of the seat is just one system of law among others, no longer elevated to the status of having the exclusive say on the validity of an award, and the approach of the arbitrators will be very important. And then the final view, which is that preferred by Professor Gaillard, is that the validity of an award is grounded on what can be called an arbitral legal order, which legal order is transnational and has its own norms, essentially a national law theory. Now, I know we've gone from the specific to some very complex and general concepts, but that's all I wish to say. Thank you, sir.
Sunil, would you add something to these?
I mean, the practical solution is, one, you can try and amend the New York Convention that to be more prescriptive. In reality, that's not going to happen. In an increasingly polarized world, for countries, 173 odd, to reach a consensus is going to be nigh on impossible. So I think that's going to be the difficulty. The second is to have an international court, enforcement court, right? So is that also practicable? Again, there are question marks there. So I mean, those are two possible solutions, but I would posit that they are, at least the first one I think would be very difficult. The second one is a possibility. I think within ASEAN, there is a possibility to have an ASEAN Court of Enforcement within the realms of ASEAN. So that is something that could be considered from a practical perspective, although albeit a little bit far-fetched.
Punun, could you add to what Kim and Sunil have said?
Thanks. Trying to explore potential establishing an international standard, I think that's going to be very, very difficult. But I'm just thinking aloud, and perhaps to share with all of you. I think that's just, I mean, we have got these different jurisdictions. They've got into very detailed, complex explanation of why they've reached decisions and the way that they've decided. But if we go back to basics, arbitration, when arbitration practitioners, we always say that party autonomy, all right? The party gets to choose a neutral seat because they do not trust, the jurisdiction of the respective parties. So they decide, say, you might give you an example. A party, B party decide to choose C as the seat. Now, if the courts do not recognize the seat's annulment of the arbitration award, then that defeats the whole purpose. Because when party chose a seat, they recognize that the courts of the seat would have jurisdiction over the arbitration, they recognize that it is the seat, the court of the seat, who will be setting aside or here setting aside applications and who has the power and jurisdiction to set aside the awards. And if, let's say, court A, or rather jurisdiction A, doesn't recognize this setting aside, what will actually happen is this. B has got assets in jurisdiction A. Awards is now in seat C. A can go and try to enforce the award in the jurisdiction A, which is the jurisdiction of that particular party, which B did not trust in the first place. So if that's the case, then what happens? So I think if you go back to basics, when you talk about party autonomy, the whole reason that parties want to have arbitration, international cross-border transactions, is to have a neutral seat. And once you accepted that the neutral seat would have the jurisdiction and power over the award in terms of setting aside, you should likewise recognize that your own jurisdiction should recognize that annulment when it happens. Otherwise, there's always a possibility that one can go back to A courts and try to seek enforcement of the award when B, in the very first place, did not trust to have the dispute decided by the A courts anyway. So to try to come up with some international standards, I find that it's going to be very, very difficult. I think you need bodies like IBA, IBBA, ICA and all that to come together and try to work out something. But I think my suggestion is go back to basics, and that's the whole reason that why parties have chose seat C.
So can I respectfully disagree with Kolun? I think the emphasis on seat is really there's too much emphasis on it, because look, sometimes the seat is chosen for convenience, right? It's nearby. There may be other factors for choice of seat. It's a theoretical choice sometimes, right? The real issue is when I get this award, what am I going to do with it? So to my mind, the choice of seat is great. It's a theoretical point, but really I want to look at where I'm going to enforce this award. So let the enforcement court, and I'm a common law lawyer, I'm going to agree slightly with the views of the French approach here and say let the enforcement court make the call, because the assets are in the jurisdiction of the enforcement court. So let them exercise the right. Now the question is whether they exercise the right by looking at the award or whether they look at the judgment, right? So I think in that regard, if you look at the English approach, so Taya has talked about one decision. In Maximov, there is another decision involving Russian party, not state-owned, where the award was granted in favor of the claimant, set aside in Russia at 3 levels. So the claimant then goes to the English court and says, look, the Russian legal system is biased. You must set aside the award. They led expert evidence on what they perceived was an unfair judicial system. And the English court did not buy that argument, right, in that instance. It referred to the UCOS decision, but in this instance, distinguished the UCOS position and said, no, look, we're going to respect the decision of the Russian court. We may not have reached a similar conclusion, but we can't find prima facie evidence that the system as a whole is flawed, such that you did not the setting aside of the award was not lawful. So I think the focus should be on where the enforcement is, or due weight should be given to where the enforcement is. So I'm going to disagree slightly with Kolun there.
I get what Tawa has to say, but just before Tawa states, would a solution be for the parties, even before the start of the arbitration, agreeing that once the award, in the event it's set aside in the country in which the seat of arbitration is, thereafter there'll be no enforcement by either the successful party in the losing party in any other jurisdiction? What could you say, express your view on that and anything else?
Yeah, I mean, thank you, Dato. That's certainly a very interesting and proposition that the arbitration agreement itself provide that the decision by the seat court is final, and once it has been set aside by the seat court, then it cannot be enforced in any other jurisdiction. The question of whether that arbitration agreement will be enforced in all jurisdictions is up for debate, because I don't think there has been such an arbitration agreement before. Certainly, arbitration agreements that limit a party's recourse beyond the arbitration have been enforced. There are provisions to that effect in the ICC. And I think in chrome alloy, which was mentioned by Luen as well earlier, the arbitration agreement did actually say that there would be no right of appeal from the award itself. And that was recognized by the courts in America. Going back to the more general proposition of what the solution may be in this circumstance, I think we have to start with first principles. At the end of the day, at first blush, it is very surprising that an award that is set aside in the seat still retains some sort of afterlife and can be enforced in other jurisdictions. But looking at the New York Convention and the use of the word may in that convention, it appears quite clear that the enforcement courts do have a discretion as to whether or not to enforce an award that has been set aside in the seat. The question really is what are the principles for the exercise of that discretion? I tend to agree with the English courts that what we should be looking at is perhaps the judgment setting aside the adjudication decision rather than the award itself. And in looking at that judgment, setting aside the adjudication decision, not recognizing it would be limited to very, very, very limited circumstances which perhaps need to be considered and particularly set out. I don't think public policy in general should be there, but perhaps certainly things like honesty and bias and natural justice should be in there. So I think if we can perhaps wrap up on that note, Datuk mentioned to me earlier that he would like to finish.
I'm just wondering whether there are any questions from the floor. Any questions? Yes.
Want to? Harold Cecil from Screen. Good afternoon. Thanks a lot for this fascinating discussion. There's two quick comments I'd like to make, and then I have a quick question. The first comment is, ironically, the French version of the New York Convention, and that's the original version also, because all 5 UN languages are the original languages, says must. So it must refuse enforcement. But the French courts, as we heard from Sunil, take a different approach. Still on Sunil's point regarding, I very much like the comment towards the end by the English decision where the court, or where it was tried to establish that some legal systems may be biased, and that's very much the approach the Dutch courts have taken in the past. So I found that very interesting because it allowed a flexible approach to, on the one hand, say we have certainty, on the other hand, we make exceptions when there's really something that's going wrong. And finally, I think we heard from Luen, then from Sunil, and then from Thaya, more or less what their views are, personal views. I'd like to hear from Kim and Dato Naban. What are your views? And please be as frank and straightforward as the other ones, because if you paid attention, you could see that the audience was really waking up when Sunil said, I beg to differ. Thank you.
Kim, could you express your position?
Thank you. I guess I respectfully share the approach of the Hong Kong courts, and with this background, this New York Convention was incredibly innovative when it eliminated, well, how do you say it, the double exequatur, where, as you recall, under the Geneva Convention, before the New York Convention in 1958, to be able to get recognition and enforcement of award, you had to apply in each court for the recognition and enforcement as well as under the convention. And so this provided a simplified, streamlined version. But that being said, and party autonomy being taken into account, when the contracting states agree to the New York Convention's terms, they are ceding to a certain extent sovereignty of their courts. We were talking about it before this session. In other words, private individuals are being given some quasi-judicial powers. But from each state's perspective or jurisdiction's perspective, I am confident, and I'm sure you all are, who've acted for states or have been involved in dispute resolution involving states, that they're very concerned about state sovereignty and about the sovereignty of their courts. And to that extent, and I did start looking at the drafting background but wouldn't presume to be able to speak cogently about it. The New York Convention recognises that ultimate residual discretion of the courts by using the word may. But the words you used about, what did you say about Dutch courts basically taking the flexible approach where generally they would seek to uphold an award, but where something's really gone, or a court decision where it's been set aside a seat, but when something's really gone wrong, then they'll step in, seems to be a very nuanced and sensible approach. Thank you.
My view is, unlike domestic judgments of our courts, arbitration, where a country is signatory to the New York Convention, takes a completely different position. You may agree to the seat, but you already recognize that it could be registered and enforced in many jurisdictions. So I think once you arrive at that position, each jurisdiction must have a say in enforcement registration. That, I think, is the position. But I think there could be an international standard that once an award is set aside in the sea, prima facie, it is not enforceable unless you come within a very limited exception. And my colleagues have already mentioned the various exceptions in different ways. But I think that's my view. To stop, to prevent completely in the way of the Qur'an, I think maybe not. But giving a free hand in every jurisdiction might create huge confusion. So there we are. I think we have just finished our time. Any other questions? Yes.
Hello. Yeah. Thank you for the panel for the knowledge-sharing session. I'm Nakiran Kumar from Sean Delamore. Without taking most of the time here, since the keynote address from the opening of the ADR week till this current session which is going on, the entire argument on enforceability or any other points we're speaking boils down to the concept of party autonomy and the minimal intervention of court. However, bringing closer to home to Malaysia, we have judgments which goes to opposite directions. Like the Court of Appeal decision in Taki Engineering and Ipoh Tower literally says that even if an arbitrator makes an error of law, the party shall just accept, and even quoted that if you go to Caesar, you must take Caesar's judgment. And then we have our federal court decision in Far East Holdings which says that if there is an error of law, the court can step in. As for some, there's a list given by the court to say the court can step in and intervene. So my question to the panel is, how do we draw the line? Where does the court intervene? And how do we protect parties' autonomy? It's just a general opinion question to the panel. Thank you so much.
So I think you have to realize Far East is a Section 42 decision.
Yes, it is.
So it is a question which has now been repealed. So it is within those circumstances that, you know, an award can be examined and set aside. But, you know, the general proposition under 37, which conforms with the model law, means that, look, if there's an error of law committed by the arbitral tribunal, you know, the courts are not going to interfere. You know, Government of India against Kane Energy, there are a number of federal court decisions on point there. So, I mean, you have to realize the distinction. Far East is a 42 case. The other cases are 37. Can I just come back to Harold's point? Harold's right. You see, in the French text, the words are ne seront refusés, right? Which when you translate into English means either shall not be refused or will not be refused in Article 5.1 of the New York Convention. So from a textual perspective, the French approach is problematic in that regard. So what the French courts have done is, let's look at Article 7. So we get round the French construction or interpretive approach on Article 5.1e. So that is the nuance within the French approach. Whereas the English approach, as Thaya has pointed out, is we are looking at very limited issues within the judgment to set it aside. To seek whether to decide whether to interfere or not. Yeah, so, you know, the French approach has its merits and demerits. There are arguments there. But I think the question that I would ask is this: if you were not intending the court of enforcement to have discretion, then why didn't the drafters impose a stay requirement in the New York Convention, Article 5, to say automatic stay of enforcement pending the award being registered or set aside in the seat of origin jurisdiction? They didn't do that. So there must be a reason for that, and that would probably support some of the jurisprudence in France and the discretion exercised in England. So, you know, points to consider.
Thaya, would you have anything more to add?
Not really. I mean, just to echo what Sunil said, that the position in France, I think they've made it quite clear that they take that position based on the Code of Civil Procedure in France, and so long as the award satisfies those requirements, it will be enforced. And then they rely on Article 7.1 of the New York Convention. Article 7.1 being there in the New York Convention obviously recognizes the right of each state to have more favorable terms for enforcement than what's set out in the convention itself. So in that sense, it's in line with the convention.
Any other questions from the floor? Yes, please.
Yeah, my name is Sushil Shankar. Short and simple question. Would it be right to summarize this entire panel's discussion by saying that France is probably the only jurisdiction where it is more likely that an award that was set aside in the seat would be enforced? And the second question is, do any of the panelists know of any other major jurisdiction that follows the French approach?
The Dutch courts, in some cases, followed the French approach. The Belgian courts and the Luxembourg courts have also, in some instances, but you know, there are decisions on either side in these jurisdictions. So the French court is not not alone. A number of courts within the EU have adopted a similar approach, but their decisions are not all one way.
If you have been following the Zulu case, you realize that the European courts have taken a very different position. The fact that it has been set aside in the seat does not mean that it cannot be enforced and registered in other jurisdictions. They want to listen and determine. That is the reason why I started off by saying there's real need for you to examine that, and maybe a formula could be adopted in the drafting of the arbitration agreement to make sure that your clients don't face these issues. You know, otherwise you take the position that there is really no agreement, and yet an arbitrator in a New York Convention state makes an award. You get into all kinds of issues. Any other questions?
Not a question, but probably just to
Yes, Kulun.
just to follow through. You recall that, I mean, it's true that the French courts have taken an approach that they would actually look at the award before deciding whether or not to refuse enforcement. They do not accept an annulment from the seat of jurisdiction just like that. You recall that I mentioned the case of government of Laos, and one of the jurisdiction where Tai Lau Lina sought enforcement was also in France. So in the French courts, similarly, even after the award was set aside in the Malaysian courts, the matter went up to the French courts, and the French courts actually heard the resistance to the enforcement on its merits, but nevertheless decided to refuse enforcement. So they actually hear the decisions, unlike what the US or New York courts have actually, how they dealt with it after the award was set aside.
Yes, Dato Sundra.
I noticed one thing about the way European courts handle it. One thing quite common is that they refuse to cease jurisdiction. They will always say, I have jurisdiction. So we have like the Sulu Award, obviously, where the Spanish court used its legislation, which is a very permissive legislation, to appoint an arbitrator. Because somebody could show that it is something related to Spain, and then they ceased jurisdiction, they appointed the arbitrator. Then when the issue was raised about there's no arbitration agreement, there's no agreement and all these things, they actually then nullified the appointment of the arbitrator on the basis that service was not followed. So they did not refuse jurisdiction, did not deal with the issue. Then the latest one, the preliminary thing, when the arbitrator shifted the seat, when his appointment was nullified, he said that arbitration was under Truma, and therefore he shifted the seat. I mean, all of us are quite stunned. Can you do such a thing? Of course, we all say in the international arbitration circle, it cannot be done. In theory, it cannot be done. Again, the preliminary award for jurisdiction was already accepted by the French court. They didn't nullify it. And then when we actually had to go through the entire process, by the time the French court made that decision, again, they dealt with not the substantive issue that there is no jurisdiction for them. They dealt with that there was no counsel general. So, I'm a bit perplexed with the entire system of enforceability and recognition, because something that is a little bit, for me, is dishonest. I would say as an arbitrator, and looking at it, looking at the theory and the facts don't meet. So there is a problem there. In fact, I made this statement that European arbitration is under stress. And it is actually being questioned. The only place that I could accept where they actually dealt with it was in The Hague on the enforcement thing. They deal squarely on the point. Again, they didn't deal with all the points. It's 1 or 2 points, typical of courts, isn't it? They never deal with all the points. They only will deal what they think is important to answer their question. So for me, the French approach at the present moment, we still will never know whether it's going to be annulled until it's done, and what reasons they're going to use. And I'll be very interested to see, because the model law is actually what they are also using, which is the same articles as the New York Convention, which that's why I say I'm a bit disappointed, to watch all this advanced jurisdiction coming out with that kind of answers to a very straightforward, if you actually go and study arbitration 101, and then this is what the answer should be, this is never the answer what the court is given in both Spain and in France. So we have to watch the space again.
Thanks, Dato Sunil, for your input. Is there any other questions from the floor? Yes, please.
Yes, I have a question for speaker. Can you share some experience and what is the most popular grounds for setting aside or annulling the foreign arbitral award? Because in Vietnam, most of the popular grounds for setting aside the arbitral award is because the foreign arbitral award is contrary to the fundamental principle of Vietnamese law. And the legal terms of fundamental Vietnamese law is quite broad, and we also have the resolution of the Supreme Court of Vietnam to guide, to provide further details and instruction. But actually, the more we introduce, the more we provide further introduction, the more it confuses the expert in Vietnam. Thank you.
How would you be able to respond to that?
Yes, I mean, in the judgments which I've read, there appear to be frequent allegations that the setting aside decision at the seat was, especially where it involves a one national party or the government is biased in a sense. For example, in Malikop, there was an allegation that it was pro-Egypt bias, and similarly in other decisions as well. I think in Maximov as well, there's an allegation that it's pro-Russian bias. So there often seems to be this allegation that it's, especially, it's a national court and it's a state in that the national court of that state, that national court will always be biased towards that state. But I think the allegation in itself is insufficient. You would obviously need cogent and positive evidence of such bias, which would obviously be not something very easy to obtain.
Kulun, could you add to that if there is other instances?
Yeah, I think if we are referring to grounds for setting aside as opposed to situations whereby annulment is recognized or not recognized in the enforcing court's jurisdictions, a bit different. I think in Malaysia, quite commonly the setting aside grounds would be in excess of jurisdiction and beyond scope of arbitration, beyond scope of submission to arbitration. Those are the more usual grounds that's been leveled. Public policy grounds, I don't think it's not very successful in that sense, in Malaysia at least. And then this, I think the gentleman just now mentioned about against the fundamental laws of the jurisdiction. Those reminds me of grounds that used to be used in India quite a fair bit under the public policy grounds. Malaysia, I don't see we see a lot of that. Mostly, if at all, there will be a question of breach of natural justice to a breach of public policy. I think that's essentially what happens in Malaysia.
Would you be able to add something?
As colleagues have mentioned, it really depends which level you're looking at, whether it's before the tribunal, whether it's before the court of the seat, or whether it's before the recognition and enforcement court. In Hong Kong, may I just comment that perhaps similarly to what we just heard about in Malaysia, but I wouldn't presume to comment, the primary grounds at the court of, and my impression is, or other colleagues here from Hong Kong, the primary grounds at the stage of the court of dealing with a set-aside application or an enforcement court are not within jurisdiction, excessive jurisdiction, or failure to accord due process, natural justice. And sometimes the last head can arise out of different approaches in different jurisdictions. For example, Hong Kong, a common law jurisdiction, generally arbitrators don't act as mediators. By contrast, there are occasions in the mainland China where an arbitrator will also provide a mediation function and caucus with parties that is not in the presence of the other party. There have been cases about that. But public policy is not a ground that is invoked very often. I'm restricting this to Hong Kong, if I may say.
Is there any other questions? We are running out of time. If there isn't, please join me to thank our panelists
for a good afternoon.
Thank you, Dato. And thank you to our panel of speakers and moderator. Ladies and gentlemen, one more time for our panelists, please. Thank you. We'd like to invite Yang Berbahagia Datuk Sundra Raju, Director of the AIAC, on stage to present a token of appreciation to our panel. Thank you to our panel. Ladies and gentlemen, before we proceed to our fourth and final session of the Asia ADR Week 2023 today, an interesting rapid-fire debate. Let us take a short networking break and we'll resume here at the auditorium at 5 p.m. There will be ushers to guide you to the pre-function area next door for some light refreshments. We'll see you shortly. Thank you.